Senate Committee on Investigations to order here on, I guess we're on December the 13th already. I mean, November the 13th already. Hard to believe calendar's flying that fast. We have some conflicts with other senators that were out of town, and they're being permitted to participate via Zoom. Senator Kim Jackson and Minority Leader Harold Jones are online, and we have more that may join here shortly. But we having a quorum, we'll go ahead and call the meeting to order. First item on our agenda is to approve the meetings from our October the 3rd meeting. If you all would just take a second to review those minutes real quick, then we'll give you a minute or two, everybody to look at that. Then we'll entertain a motion to approve those minutes. Should be right on the top of your folder.
Chairman, I'll make a motion to approve that.
All right, there's a motion to approve the minutes as presented from the Friday, October 3rd meeting. Is there a second? Second by Senator Tillery. Is there any discussion? All right, all in favor, say aye.
Aye.
All opposed, like sign. All right, those minutes are approved. You may recall that today we had intended to bring District Attorney Fonnie Willis to testify before us, and her attorneys had agreed that date was appropriate. We had agreed the parameters of the questioning for her, and unfortunately, due to scheduling conflicts on her attorney's side, we've agreed to postpone that. Most likely, that date will be December 17th. It'll either be the 17th or the 18th in that week. We'll do that. We're waiting to confirm the availability of the witness and counsel for that. So just stay tuned for that. We'll let you know in plenty of time. I would anticipate we'll have a firm answer on that, hopefully by the end of the day today, or if not, by tomorrow, we will know. And we'll get that notice out, particularly of interest to the press and other members of the public that may want to participate. Today, we're pleased to have Mr. David Amati, who's the Executive Secretary of the State Ethics Commission, with us. I think you will have in your folders for committee members a copy of Senate Resolution 292. If not, we'll provide you a copy. You might remember during the last session, we issued a new sort of resolution reestablishing this committee, extending it, and extending the reach of our investigation to also include some of the State Ethics Commission's investigation and settlement of some charges against the New Georgia Project and the New Georgia Action Fund. These are both entities that were created by Stacey Abrams. Ultimately, there was a consent judgment, as I understand it, entered into with all those parties with their consent, admitting to numerous violations of our ethics laws and going along with a $300,000 fine, which is the largest in state history. So our committee has also been charged to investigate that and find out what the allegations were, what the results of that were. And as always, one of our special considerations is to consider how we might consider to amend existing state law or to enact new state laws to restore public faith in the fairness and integrity of the election process, certainly in conjunction with prosecution of criminal actions as well. So we're going to look forward to hearing from you, Mr. Amati, if you will share with us today. Start, I need to swear you in for your testimony. If you'll raise your right hand. You swear the testimony you give in this committee today will be the truth, the whole truth, and nothing but the truth, so help you God. All right. If you would, David, just introduce yourself and let the committee know your role. And I need a little background about the State Ethics Commission. It's changed names numerous times over the last 5 or 6 years. If you could just kind of walk us through your involvement, the makeup of the commission, and what the statutory authority for it is, and just give us a little background so we'll have some context before we get into these specifics.
Sure. Happy to, Mr. Chairman. My name is David Amati. I'm the Director, Executive Secretary, Chief Sanitation Officer of the State Ethics Commission, go by many titles. I've held this role for almost 7 years now. Prior to that, I was the Chief Assistant District Attorney in Douglas County, and I worked in the DA's office close to a decade there as well. I came into this role in early 2019. As Chairman Cowsert said, it had a different name at the time, a much more bureaucratic, long-winded name. We tried to simplify that. But the State Ethics Commission is really tasked, has a lot of different jurisdictional areas of oversight, but the concept is simple. We're tasked with overseeing the influence of money in elections and making sure everyone's playing by the rules, everyone's on the same playing field, everything's on the up and up. The Ethics Commission has been around for 35-ish years. A lot of these ethics commissions here in Georgia and other states sort of flowed out of the Watergate controversy, and different mechanisms were put into place throughout the country following that, following all of that. The Ethics Commission, as it relates to, let's call it the political sphere, because we do oversee sort of the lobbying realm, some development authority things, but within the political sphere, we have regulatory oversight over a number of different types of entities. The first and simplest one is a campaign committee. Everyone up here has a campaign committee. Some may have more than one. But the oversight of the campaign committees is quite simple. Campaigns, which are capped in the amount of money they can raise from each individual donor, can raise and spend money to help that individual get elected, to help them fulfill their oath of office and their duties. And we make sure everything's being done properly there. If you're raising money for mailers or canvassers or maybe a legislative aid, those are all sort of common type things we see here at the legislature in particular with those campaign committees.
So on those campaign committees, obviously, if you're in the state house, it would be committee to elect, Joe Johnson to state house or whatever the name might
Right.
be. Same thing with state senate. And then all the statewide offices like governor, lieutenant governor, et cetera, under the same rules on campaign committees.
Correct. And the same is true with, we go everything from governor down to your city council, your board of education, your probate judges, and everything in between, all the same.
So any elected office in the state of Georgia, not just on the state level,
Correct.
county commissioners, city councilmen, everybody.
If it is an elected position in the state, we have oversight unless it's federal, and mercifully, we do not have jurisdiction there.
Does anybody else have any type of oversight of those type of campaign committees? Do any local district attorneys or other type of law enforcement have any authority to investigate or regulate or control them?
I wouldn't say regulate. I, by statute, am statutorily empowered to confer with federal, state, local law enforcement, and we have done that at times. So if there's something that violates maybe a state ethics law, but appears to be criminal, I may call the DA or the Attorney General, the U.S. Attorney's Office, and the corresponding law enforcement entities.
Okay, so if there's a violation of these various campaign finance laws, that can be a criminal offense?
It's really fact specific, Mr. Chairman. It just kind of depends. And I'll give you an example. If a campaign committee fails to disclose some expenditures in a report, that would not necessarily be criminal. That might be poor compliance work. That might be a a sheet in the spreadsheet got overlooked when they're inputting. But if a campaign committee were to say, take campaign dollars and pay for a private vacation for their family, which has happened, that would be something we would consider potentially criminal and refer to the appropriate entity.
And what would be the appropriate entity to prosecute criminal type violations of our campaign finance laws?
Typically, I would start with the GBI and the Attorney General. And facts may dictate a pivot there. It may be federal. And sometimes we get into wire fraud type stuff where that may be more appropriate for the feds.
So if it involves interstate transfers, et cetera, it might be a federal offense as well.
Correct.
So a federal prosecutor will be the one to investigate or prosecute that.
That's correct.
But if it's just a statewide, my little Senate campaign committee, that would most likely be just within the state of Georgia.
Correct.
Does the Attorney General have the first say on that, so to speak, if it's a state elected official?
I don't know if there's really a say so much. I have found, and listen, I come from the DA background. This isn't a shot at DAs. I've got many good DA friends, but I think they'll be the first one to tell you when I approach DAs with some of this type of subject matter, they're like, that's outside of our wheelhouse. That's outside of our expertise. Whereas in the Attorney General's office, they have a dedicated unit that represents us. They understand our laws, and they can coordinate with the criminal division over the AG's office.
So they have jurisdiction,
They have
authority to
jurisdiction.
prosecute.
Correct.
And what about on the county level offenses? Does the Attorney General have the authority to go prosecute somebody, down in Colquitt County, or does that fall to the local county district attorney?
I wouldn't say they don't have authority, but I think from a fact standpoint, those tend to be more appropriate for the local DAs.
Is that something you make the decision, the referral? You would contact the local law enforcement or prosecuting authority to say, we found this violation. Would you take a look at it and consider prosecution?
That's correct.
The Ethics Commission does not have the authority or a unit that can conduct prosecutions.
Not criminal
So
prosecutions.
you
No,
can't bring a criminal indictment.
Correct.
You just refer it to the either the Attorney General office or a local authority to let them explore that possibility.
That's correct.
Okay. That doesn't happen very often, does it?
Fortunately, no, more than, maybe we'd like, but not terribly often.
On a state house or state senate seat, what are the allowed amounts of contributions for a campaign cycle?
So for a non-statewide office, so for state house, state senate, district attorney, superior court judge, county commission chair, it's 3,300 for your primary, 3,300 for your general. And then you have the option, there's a form you can fill out called a choice of option of separate accounting, a CUSA form that basically allows you to bundle for multiple elections at once. Now you have to account for those separately. Can't spend general money during the runoff. But you in theory could bundle your 3,300 for the primary, 1,800 for that runoff, another 3,300 for the general, and 1,800 for the runoff. With the one caveat that if you take money for an election, you don't ultimately appear on the ballot, and there's not generally going to be a general election runoff except in special circumstances. That money does have to go back to the donor at that point.
How did we come up with those dollar amounts? Is that statutory? Did we as a legislature set those limits on ourselves?
So the limits were set initially 20, 30 years ago, and they were set at a number, I think at 1,000. But within that code section, it ties it to essentially inflation, the credit bureau. And so at the end of every gubernatorial cycle, we adjust for inflation and raise or lower those limits based on inflation or deflation.
Do you share with us what's the sort of policy reason that there would be limits on the amount of donations that any one donor can give to a campaign?
Yeah, that's getting into policy a little more, but I think the general argument would be, money is speech, First Amendment. There's plenty of Supreme Court case law on that. But the idea that equitability in speech is that, if there aren't limits, maybe certain people would have much more speech authority and power in our electoral process than others, and thereby have more access to those who are elected, I think is the general argument.
And more influence on who wins elections.
Correct.
So we may not want billionaires to be able to come in and overwhelm the field, so to speak, and just handpick their folks by a great expenditure of promotion for them, right?
I suppose the libertarian argument would be just put it all on paper and let everyone know. And I'm not getting into agreeing or disagreeing with that, but that generally is the concept.
And in that, putting everything on paper and letting people know, what are the reporting requirements? What's a candidate do? You can't get 3,300 the campaign. If you receive that money, where's it go? Do you have to tell the Ethics Commission or the public? How's that? Walk us through how that works.
Yeah, so there are set reporting periods for campaign committees, and I'm sure we'll get to this, the other types of committees, but they all have, schedules. And essentially a campaign committee at each reporting requirement has to disclose what money they've raised, where they've raised it from. If a donation is received over $100, they have to itemize that, meaning they have to name the donor, they have to provide the occupation, the address, those sort of things. And they have to do that for all their donations. And then they have to also outline all of the expenditures they make from that campaign account, what they spend it on, whether it's yard signs, mailers, canvassers, a district office rent, whatever the case may be.
So by disclosing who the donors are, we get a lot of press here today. If they review these publicly filed documents, you could see who might be attempting to influence a candidate or an elected official. And other donors can also see where the money's going, and maybe they want to counter it by
Correct.
funding the opponent or whatever.
Correct.
Sort of transparency is the ideal here, so that everybody knows what's in their deck of cards.
Yeah, transparency is the watchword. I tell people my job is not to get in the middle of these races, but to just make sure everyone knows the facts. And that's what the Ethics Commission is really tasked to doing, is making sure everything is transparent to the public, to the press. I know we have some friends there here, and to the other campaigns, so that people know who's involved in what they're doing.
How frequently are those contributions and expenditures reported?
So under current law, in a non-election year, it would be twice a year, and in an election year, it would be 6 times a year. Those dates in non-election years differ depending on the type of office held. We, with your help in the Senate, we passed SB 199 this year, which I helped spearhead. And moving forward, beginning next year, we're simplifying that. It's just going to be quarterly every year. I don't care, respectfully, if you're a senator or a city councilman. I don't care if it's an election year or non-election year. It's the same 4 days every year. Everyone knows what days they're going to be, and there's just going to be more consistency. And in part because there are people who violate ethics laws unintentionally, because they forget, especially more at the local level, they forget dates, they get confused by certain. So we've tried over the years to just make this much cleaner and simpler. And so moving forward, it'll be 4 times a year for those campaign disclosure reports.
And who is allowed to contribute to a campaign? An individual can do that?
An individual can do that. Corporations in Georgia can contribute to campaigns. The sort of restriction is U.S. citizens or U.S. corporations. We don't allow foreign dollars to influence our elections in Georgia.
But foreign means from another country, not another state.
Correct.
So California, if they want to weigh in Georgia politics, can contribute to any of these campaigns subject to those limitations.
Correct.
Okay. And they can do that as an individual, Mr. Movie Mogul, or they can do it as a corporation,
Movie
Microsoft
Mogul
Movie.
LLC. Right.
Okay. No limitations on if you've got associated groups, like if I own a law firm that's it's incorporated, I could give personally, I could give to my firm, and could also say a spouse or other related folks if
Yeah.
they wanted to.
I'd say 99% of that is correct. You can give the maximum amount, your spouse can give the maximum amount. If you have a law firm, that firm can. Where it gets restricted is if you have 10 LLCs that you are, say, the sole shareholder of, that becomes just a shell game, and there are certain things in place that don't allow that. But that is very rare that we see that.
Okay. And so that covers your general campaign committees. What other type of entities are there that are allowed to raise and spend money on behalf of candidates?
So the first one, the simplest one, is a PAC, a political action committee, and boiling this down real simply, they do one thing: they donate money. There tends to be some confusion about different types of PACs, but the true PAC is an entity. Corporation X has an affiliated account for their PAC that doles out contributions to candidates for office. And if in a calendar year that PAC exceeds $25,000 in giving, they then have to register and disclose all of their money in and all of their money out with the Ethics Commission.
So they would have to tell you what money they raised. And it could be, if it's Kroger Incorporated's employee PAC, it could be coming from executives or employees of that business.
Correct.
Or an industry even.
Correct.
You just would have to tell who donated to you and then who you gave the money to.
That's right.
And that would typically be to all these campaign committees. You'd be writing committee to elect Bill
Yeah.
Cowser, not me personally.
Correct.
Is a candidate allowed to accept personal contributions
A candidate,
Yeah.
personal contributions
or
from
an elected official?
from a PAC.
Yeah.
Yeah.
Or from you. If you really liked me a lot after today and you wanted to give me $500.
My board might have a problem with
Yeah.
me cutting checks to people I oversee, but generally, yes.
But I thought it had to go to the campaign committee, not to the individual.
So,
I might have been missing out on a lot of possible contributions.
there tends to be a difference, just respectfully, in this building that we operate in, it goes to the campaign committee. But what you do see often at the local level is they don't
Right.
create an incorporated campaign committee. It's just a separate checking account at their local bank.
Okay,
What you cannot do,
they account for the money separately as a
Yes.
campaign
it
contribution.
has to be a separate depository account. It cannot be money going into their personal checking
Can't
account.
put the $100 bills in the overcoat pocket.
Not in a long time.
All right.
Yeah.
Fair enough. So these political action committees also report on the same type of schedule, so everybody knows who they're supporting.
Correct.
All right. So let's just say the marijuana industry is trying to get a bill passed and they're donating to people trying to get influence with them or persuade them to vote their way. You've got a paper trail where you can see that what
That's
they're
right.
doing. And
That's right.
ultimately, these reporters can say, hey, that politician, he was bought and paid for. You can see what,
You can see the flow of the.
connect the dots.
Correct.
Tell us about a quid pro quo. What's that mean?
So a quid pro quo is it essentially mirrors in criminal law the bribery statute, which is I will give you money in exchange for doing X, whether it's legislatively or at the council level, maybe a zoning issue, right? Or a DA, maybe a criminal indictment. There is an expectation that donors tend to give to candidates who have similar ideals. And so that is not the same thing. But when there is an overt, call it conspiracy, to give money in exchange for an action in an official capacity, that's where we get into quid pro quo and essentially the bribery code.
And that's illegal.
That is illegal.
Okay. And is that one reason why we have this disclosure? So you have the ready evidence in front of you if there's such an accusation to say, well, they did or they did not give money.
Yeah, in a hypothetical, let's say someone has evidence to bring to their local DA or whoever that a county commissioner passed a zoning ordinance, and I've got evidence that they agree to do it. Having that money trail is sort of circumstantial evidence to that case, right?
Got it.
And so that's another reason among many that we have these disclosure reports.
Okay. What other committees are, we got campaign committees, we got political action committees. Are there other entities that are allowed to receive contributions and make contributions or expenditures to support campaigns?
Yeah, so the next one would be what is defined in Georgia code as an independent committee, but the common nomenclature is super PAC. And this is where you get people who get confused about PACs and super PACs. So PACs, they cut checks, and that's sort of the ball game. Independent committees play in the middle of the process of influencing elections. So an independent committee is super PAC. They raise money, they spend money. Notably, unlike campaign committees, independent committees are uncapped. They are not subject to contribution limits. So independent committees can take $1 million check from a donor if that donor so chooses. And what independent committees do is they engage in what we call express political advocacy. They advocate for the election or defeat of a particular candidate. They convince people to vote one way or the other, whether it's through mailers, digital ad buys, canvassing, et cetera. That's the space they operate.
So they can be essentially acting like a campaign committee, but independently from the candidate's own self-control committee.
Correct.
And they can advocate on any candidate's behalf if they want to.
The only restriction is they can't coordinate their messaging with that candidate.
So that's the word independent. That's what
Yeah.
we're talking about.
Yeah.
Okay. Well, that makes sense. There are no limits on the amounts you can contribute to them.
No
They have
limits.
to be reported.
They do have to be reported. So before an independent committee can raise or spend a single dollar, they have to register with the Ethics Commission and they have to disclose periodically. Their schedule is different than a campaign's. We've tailored theirs more closely to the primary and general elections, but they have to disclose all the money they raise, what money they spend, who they spend it advocating for, and how they did that.
And they can work or advocate for multiple candidates if they want to.
They can.
They could pick people from either or both parties at the same time if they supported or shared their philosophy, so to speak, or,
Right.
or outlook on things.
Correct.
Okay, I see things, mail pieces
Right.
that come from groups like, for example, there's a group wants to impose term limits on the United States Congress. And it appears to be bipartisan. If you get a mail piece from that, they may be advocating for their issue.
Right.
Persuade people to ask their different elected officials to vote for a proposal that supports their agenda, or else for their individual campaigns to let's get some people in office that
Right.
share our philosophy.
And that's a great example where you do see sort of an option of one or the other. Sometimes you see say a term limit group advocating for an individual for Congress. Sometimes you see a term limit group just advocating for term limits. And what we call that issue-based advocacy and not express political advocacy, because they're not identifying a candidate. And that differs whether they have to report or not.
If they make such expenditures, a TV ad or a mail piece or digital ads and things now, do they have to disclose what the source is that they did it? Let's say it's Term Limits USA.
Yeah.
Do they have to say paid for by Term Limits USA?
Yeah. So in a couple ways they do. Independent committee laws require any advertisement they make to identify who is paying for that ad. Over wire, so TV, radio, the federal government also requires that sort of separate from the state.
And as you see these, or you hear them on the radio or TV, this ad is approved by a candidate, so and so and so. Is that a requirement? If it's being paid by a campaign committee, do you have to say, this is my campaign committee that's approved this message or whatever?
I might get in a little trouble saying this. Over radio, yes, because it is a federal requirement. There is technically not a requirement at the state level that a campaign committee has to put the paid for ad on their mailer. It's required for independent committees. It's required for leadership committees. But not, and I don't think that's intentional. I want to be clear. I think that was just an oversight from 20 years ago,
Right.
when it's being dropped in every little bucket.
Ordinate, basic sort of philosophy behind that is if you're going to be attacking somebody, promoting somebody, own it. Let them know, that you're the one doing it. It's not some nefarious, black money or whatever that's done. Okay. So the same thing goes with political action committees. They have to disclose if they're the one doing the promotion, or.
So if a political action committee doesn't really do the promotion, they just cut the checks. If they move into promotion, they've become an independent committee. And occasionally you do see what we call a hybrid where they're both. But once they move into that advocacy, then they also have to.
Okay. Other types of campaign organizations or people that have to register with you?
So there's ballot committees, and these sort of these are across the spectrum. There are ballot committees, not advocating for this issue one way or the other, but it's come up a number of years now as sports betting, right?
Sure.
And talks of a constitutional amendment. If it were put on for a constitutional vote, there would be ballot committees advocating for and against it. You also see it at the local level with your T-SPLOST, your E-SPLOST type initiatives. Those entities that advocate for or against, say, the SPLOST have to register and disclose with the Ethics Commission the money they're raising, where they're spending it on a regular schedule.
So if you are Caesar's Palace or DraftKings and you're promoting a constitutional amendment to allow gambling, you've got to disclose how much money you're spending, where you're spending it, where it came from.
Correct.
Okay. Any other type of committees that have to register with you or report?
Then you get into the leadership committees, which are a relatively newer mechanism in state law. And the leadership committees are tied to either the incumbent governor or lieutenant governor, or the party nominees for governor and lieutenant governor, and then the House and Senate. Both caucuses in both the House and the Senate have 2 leadership committees each. And leadership committees essentially have to do the same thing. They have to register with the Ethics Commission, disclose the money they raise, where it came from, and how they're spending their money and how they're influencing certain elections.
Are there limits on the contributions they can receive?
There are not.
Can they get them anonymously, or they must be disclosed?
Anonymous donations are illegal.
Okay.
So let's say a candidate receives an anonymous donation, And this happens at the, maybe the local level. There's a, you know, a fundraiser to barbecue and there's a, you know, that bowl in the middle, people, you have to you really have to know who's putting the money in. State law requires if you receive an anonymous donation, you get a bag of cash in, you know, the PO box. You're required to transmit that to the Treasury. You have to notify us, disclose it, and then transmit it back to the state. You can't keep it.
You can't keep it and use it for your campaign.
Correct.
And on those, all of these entities that support various types of campaigns, are there limitations on when they can accept contributions? We all hear, we're told you can never receive a contribution or even solicit for one while we're in legislative session.
So the time restriction for receiving campaigns is really limited to y'all. That is a legislative thing, and a statewide constitutional office thing.
That wouldn't apply to county commissioners.
Wouldn't
or-
apply to county commissioners or DAs. Someone running for federal office doesn't apply to that seat. But you know, state senate, state house, constitutional office, those campaign committees cannot accept money during legislative session.
So a PAC can receive money during legislative session, but they could not donate to a candidate during that blacked out time period.
Correct.
What about an independent expenditure committee?
They have no limitations on when they can raise and spend money.
How about the leadership committees?
They have no limitations on when they can raise, receive, or spend money.
And I presume that's the same for ballot committees as well.
Correct.
Have we covered all the various mechanisms for raising money to support candidates or public initiatives?
If there are more that I don't know, we might have bigger problems, but I think that's about it.
What's a 501c4?
So a 501c4 is a charitable nonprofit that engages in issue-based advocacy. So a 501c4 might be an entity that is pro tax reform, and they can raise money. They have, and I want to clarify, I am not a federal tax lawyer. If anyone's watching, do not take my advice on your taxes. That would be a mistake. But my understanding is these 501c4s have certain tax exceptions. They don't have to pay certain, you know, federal or state taxes.
So we've all heard of 501c3, a charitable organization.
Right.
You can make a donation to those and it is tax deductible.
To the Red Cross.
Okay, and that's set up by the Internal Revenue Service. It's a federal code.
Correct.
And do you know whether a 501c4, an educational organization, a contribution to those is tax deductible?
I believe it is.
Okay. Do you have any type of reporting requirements, the state of Georgia, that we require these organizations to report to us?
So yes and no. From the Ethics Commission standpoint, we sort of take an approach of we don't care what your tax designation is. We care about the activity you're engaged in. So we have had entities that are maybe a C3 or a C4 get on our radar and raise that issue. And our response has been, we're not worried about the tax implications. That's someone else's problem. We're concerned with what you're doing. And if you're engaged in tax reform education, if you're advocating to the public and spending money saying tax reform is good, we need lower taxes or we need more taxes to provide these, you know, programs, we don't care about that. When you engage in the political space involving offices, that's when you come onto our attention, whether you're a C3, a C4, a 527, a C6, whatever it may be.
Now, do they have to report to you if they spend money to advocate for a particular candidate?
Yes,
And that's a state reporting requirement.
correct.
Do they have to report to you their donations?
Could they do?
And are those specified or designated as to who the donor is, or may they be anonymous?
Those have to be designated as to who the donor is as well.
Are there limitations on what those educational type organizations, charitable educational organizations, are there limitations on the amount they can spend?
No.
Are they allowed to contribute directly to campaign committees?
From my standpoint, that's not a problem. I don't know if that creates tax implication problems for those
Yeah.
entities. But they're a corporation like any corporation, in our eyes.
Um, we hear the term dark money.
Sure.
What does that mean?
Dark money or shadow money, you also hear that term. That is money that is being spent by a super PAC to influence the election, to influence the result of an election, but it's not being reported and disclosed. And so we call it like shadow money because you know there's something in the shadow. You can see something, but you can't tell what it is. You know these mailers are going out, you know their ad buy is going out, but you don't know who's paying for it. You don't know who's funding them. There's no real transparency with who is influencing this process.
Are they illegal?
It is illegal.
Okay, so in Georgia, our objective, our laws prohibit dark money, which is essentially anonymous contributions that are not disclosed and expenditures that are not disclosed or reported to the Ethics Commission.
Correct.
Is that a criminal violation?
My understanding is at this time it is not.
So what do you do if I'm running for state senate and all my friends start saying, man, you ain't gonna believe these mail pieces we're getting, and it doesn't tell us who they're coming from, but they're crucifying you.
Yeah.
And I take that mail piece to you and say, Mr. Amati, this is not being fairly reported, or have you seen any report of this expenditure?
Right.
What do you do?
We take a couple different actions. First, we have to identify who's funding it, what person or organization's behind it. And sometimes that's easier than others. Once we identify it, we file formal ethics charges against that group or that person. We will, at that point, issue subpoenas for financial records. If we know the vendors that are, conducting or creating the mail pieces in this scenario, we'll subpoena those vendors for evidence of these transactions to help prove that money was being raised and spent and contracted out to do that. And we'll move forward with a formal ethics hearing in front of my board.
Do you have subpoena power as an entity?
I do.
So you could figure out who printed
Yeah.
the hit piece, we call them,
That's correct.
and you could then subpoena them and say, who paid for this?
That's correct.
Kind of get to the bottom of it. If you
Yeah.
find a violation, what do? File a complaint against them?
Yes.
Commission itself can file a complaint, or would it be the aggrieved party?
The commission can file. So third-party complaints are accepted. We do take those. We screen them. So with these aggrieved party complaints or concerned citizens complaints, sometimes we'll review the complaint. We will not automatically accept it, but the standard is pretty simple. If the allegation states a violation of law and some sort of fact to support it, whether the fact is true or not is irrelevant. If the allegation, if true, would support a violation of law, we accept it. On the alternative, we do file our own commission instituted or initiated complaints as well. And that's the majority of the complaints.
You have an investigative staff of some type of investigators that can help you do that?
I do.
Okay. All right. And if you find a violation, not just dark money, any of these campaign laws.
Sure.
What do you do?
So
You generate a complaint.
we generate a complaint. We issue subpoenas. We conduct our investigation. And again, this gets fact specific as to what each investigation will need. But once we conclude our investigation and feel comfortable moving forward, we schedule it for what is commonly known among lawyers and the public as a probable cause hearing.
Okay.
It's that same probable cause threshold as a preliminary hearing in front of our board.
Okay, so that is done within your agency. You're not going to Superior Court, Court of Appeals, or Supreme Court, or anybody.
Correct.
You have that capacity. Your investigators say, here's what we've found. We believe this is a violation. And then somebody within your agency makes a determination. Yep, you got a case, or no, no probable cause for this
Yeah.
mistake.
So my staff will, at these commission hearings, which are public, live streamed, anyone can attend, they present evidence to prove probable cause. And at that point, the board of commissioners and so I probably should explain this too. So the Ethics Commission is comprised of 5 commissioners. They are appointed public officers. 3 of those individuals are appointed by the governor, though one has to be from the opposite political party as the governor. One is appointed by the Speaker of the House, and one is appointed by, I believe, I'm gonna mess up the nomenclature, so on a Senate thing, so I apologize for that.
Committee on Assignment.
Chairman of the Committee on Assignments, I believe. Is it the president or chairman? I'm not sure. But I think the chair of the Committee on Assignments statutorily has the appointment from the state Senate.
Okay. So that's the 5-person commission. Do they hire you?
They hire me.
You're not one of the commissioners.
I am not.
You're their executive director.
I run it for them. They hire me. They effectively sit as the tribunal, kind of a 5-judge panel, if you will, that determines, yes, probable cause has been met, we can move forward, or no, you haven't met the threshold. Either kill it or bring back more evidence or something, but we're not there.
So if you move forward, what is the next step? Is there some type of like prosecution or a hearing to determine whether there have been violations?
So at that point, moving past the probable cause hearing, we would then refer it to the Attorney General for essentially a full bench trial that they would represent us at in the administrative courts. And that ALJ, that administrative law judge, would sort of issue the final ruling. Our board gets to review any judgments from the ALJ, but it's only happened once in 7 years where there was disagreement. So generally that ALJ, if the case proceeds to a full trial, will oversee and hear a full bench trial involving both parties, of course, and make issue an order finding that the law had been broken by preponderance of the evidence, and if it had, issuing a monetary penalty.
Okay, so let's talk about the remedies that are available to the State Ethics Commission. You just mentioned a monetary penalty. You
Correct.
can't put people in jail.
No,
They can't convict them of a crime,
no,
but you can determine that they have violated our campaign finance laws.
correct.
And what else can you do? Can you slap them on the wrist? Can you make them resign their office? Can you just make them pay you money or refund donations? Give me a range of the remedies available to the State Ethics Commission when you have found a violation of some sort.
Yeah, so the first is the most common one, a civil penalty. We institute a civil penalty based on, and there's a lot of discretion here for the judge and for us when we negotiate these things, but based on the statutory fines that are laid out for each violation of law. That's the civil penalty.
So we've set that up in the code, what
Yes.
the penalties, the civil penalties are, because it's not a crime.
Correct.
Okay.
The next thing that can happen, if we see that someone has, and I'm going to be very intentional in my wording, maybe taken money they should not have taken in a personal manner, we can order them to pay that money back. And we have done that in the past. That's separate from any fine.
So they take campaign funds and go on vacation to Europe.
Yeah,
You figure that out, you prove it, you have a hearing and the determining body says, yep,
yeah,
they did it. And then you can say, here's your civil penalty, or we want you to reimburse
yeah.
somebody for the amount you spent.
Yeah, and what we've done in those cases, we had one a couple years ago where we said, all right, we're imposing call it a $30,000 civil penalty, but we're also requiring you to refund your campaign
Okay.
the money that was taken.
Yeah.
Because we're not going to institute a civil penalty that leaves you enriched from essentially.
Penalty could be less than the cost of the vacation.
Right.
Okay.
So that, and we've had instances where people have had to take loans out to pay back the money that they improperly took from the campaign.
Okay.
So that's something we've done at times. You get into wonky stuff like development authorities. We do have with development authorities the ability, technically I do, to remove them from that post if there's certain findings have been made. But with the general campaign, independent committee type stuff, we're really limited to the monetary side of things.
You can't make a candidate step down from office or be ineligible to run again.
No.
No real public reprimand or whatever, or just what becomes the holding, I guess, is released to the public.
Right. The holdings released to the public, it's out there. The one exception a few years ago, I think Chairman Mullis carried this piece of legislation, which said if you owe outstanding fines, civil penalties, dollars to the Ethics Commission, you're ineligible to stand for election in the General Assembly. That
And
would be
there-
the one exception.
Am I right? There can be these type of fines or penalties if people fail to file those required disclosure forms, or if they exceeded the contribution limit or something like that?
Correct.
Okay. How busy are you guys? You getting a lot of complaints, or are people pretty well complying with the law as far as you can tell?
We're busier than we were 6 months ago. These things
Campaign
happen in
season.
cycles. Yeah. I will say, and we're busy, but I will say, and this is not a me thing. This is, credit to my staff who've done a great job. When we came on 7 years ago, we were a lot busier than we are now, because I think there's a better understanding that if you get out of line, we'll do, that was not always the case of the Ethics Commission, I think would be a kind way to put it. And so we've seen increased compliance over the years. I will not be all negative. I think that has been a good development, but we are pretty busy right now.
I've been aiming my questions at the candidates.
Yeah.
What about all these various types of committees that register with you? What happens if you find a violation on their part? Well, what are your remedies there?
Similar.
Political Action Committee, let's say,
Yeah.
one of these independent committees.
Similar. They're going to be limited in scope to the monetary side of things. You're not really going to have the sort of taking illegally part. You're just going to have the civil penalty and violation. The process is the same. We identify a case. We feel we've got evidence to charge it. We file the complaint, issue subpoenas to do whatever investigation there may be, and then take it forward to a hearing at the appropriate time.
So last January in 2025, I think it was January 15th, your commission announced that you had a settlement on an ethics investigation with the New Georgia Project and the New Georgia Action Fund. We were in legislative session, read the press, heard about this, and we're like, whoa.
Yeah.
That's clear violations of the allegations anyway, were
Yeah.
clear violations of the law. Would you just tell us a little bit about that particular claim? How did it arise? Did an individual citizen file this complaint? Did a candidate file it? Did your investigators figure it out somehow?
Yeah.
Explain to us a little bit about that situation, because we had a Senate resolution after that expanding the scope of authority or jurisdiction, so to speak, of this committee. And we're charged with investigating that and finding out what happened, why, what the remedies were, and can we stop that type of abuse of our campaign finance laws in the future. Walk me through it. I guess my first thing is, what is the New Georgia Project? What type of entity? You just went through 5 different ones. Is that entity, and was it registered with the State Ethics Commission?
So what the New Georgia Project and the New Georgia Project Action Fund. So we talked about tax designations. The New Georgia Project was a 501c3. The New Georgia Project Action Fund was its affiliated entity, the 501c4. And this is why I said we don't really care about the tax designation. We care about the conduct, because that's what triggers or doesn't trigger Georgia law. So the New Georgia Project was a C3 and a C4 founded by Stacey Abrams in, I believe, 2013. It was a voter engagement organization. What it became was an unregistered independent committee that was failing to register, disclose, and report the money it was raising and spending to influence the 2018 and 2019 elections.
So those designations are IRS designations, and they are for charitable educational organizations.
Correct.
Georgia law prohibits them from directly engaging on behalf of specific candidates.
Georgia law doesn't really distinguish based on tax designation.
Okay.
We say if you're going to engage in this conduct, you have to disclose.
So if you're going to act as
And I, sorry to cut you off.
no, you go right ahead.
I may be wrong about that. The corporations division, the Secretary of State's office may disagree. That's outside of my sort of
Okay.
bandwidth.
So their little designation is a report to the Internal Revenue Service determining whether they owe tax and how much or whatever.
Correct.
But their activities get them under your purview.
That's right.
And if whatever their deal with this, with the IRS is, if they are acting as a political action committee or as an independent committee or a campaign committee, they have to register with you.
That's correct.
And had those groups registered with the State Ethics Commission?
They had not.
Okay, and were they required to do that?
They were.
Why?
Because, and I'm going to back up if that's okay.
That's fine.
You
Help
asked,
educate us.
you asked how this started.
Yeah.
I think there's a misconception that this started when I took this job.
You've been in your job since 2013.
Yeah,
Okay,
right.
right? Whatever the name of your commission is,
Right.
did the same thing. We changed the name back and
Yeah.
forth. Okay, but you've been the man
Since 19.
since 2019.
19.
Okay,
So this investigation began with a third-party complaint in 2018, 9 months before I took this job. And the allegation involved the Abrams for Governor campaign, potential issues of coordination, whether state law had been broken in the process. And the staff at the time began investigating this. And at some point in their investigation, the New Georgia Project came across their radar. Primarily, I think, through social media, because they were seeing advertisements made on social media for paid canvassers, statewide field offices, things like that. At some point, I wasn't here, but according to affidavits and things like that, my predecessor told them to shelve it, put it in a closet.
shelve the investigation.
Correct.
Okay.
Did not.
This started back in 2013, 6 years before you were hired.
So the organization started in 13.
Okay.
The investigation in 18.
Okay, so the 2018 general election,
Yeah,
people started complaining. This group is not just being an educational group. They're acting as an entity that's impacting elections and should have registered. with you.
the complaint technically dealt with a different group, but that investigation led to this group. And that's what the investigation in 18 was. At some point, the people in charge at ethics said, shelve it. I don't know what the motivation was, and I'm not going to speculate. That individual was ultimately terminated, and the hiring process and the need for me essentially arose out of it. And when I came on during session in 19, the commitment I made to the board, to the public, was I don't care what investigation's been closed. I don't care why they've been closed. If something was closed and it shouldn't have been, we will reopen it and we will do whatever is appropriate. If that means dismissing it 6 months later, that's what we'll do. If it means prosecuting it civilly, that's what we'll do. And so it was sort of reopened when I came on. The investigation had begun. And from there, we began finding a lot of evidence that what this group did was they tried to influence the 2018 election results by advocating for a candidate or candidates to get elected into office.
So they were doing more than just general education or voter registration.
I think some might argue all they were doing was advocating for the election that
Right.
year.
For a particular candidate,
Correct.
and that would be Stacey Abrams.
I'd say 95% of it was for Stacey Abrams. There were some mailers that they cut and sent out for the statewide ticket.
That had other candidates.
That had other named candidates on there.
Was it the Democratic ticket that was being supported?
Correct. But yeah, 95% of their activity was, there were, in the course of the investigation, we obtained records of, the scripts that door knockers and canvassers get. And it was, here's why you should vote for Stacey Abrams, phone banking similar, a lot of digital ad pushes, things like that.
So those are activities that our citizens are allowed to do. To advocate for candidates, go canvass on doors and knock and suggest you vote for somebody.
Correct.
So the activity wasn't wrong. What was in violation was they didn't report what they were doing as our laws require.
Correct.
what type of entity would you consider them to be under your disclosure laws?
They were an independent, well, they were a super PAC. They were an independent committee.
Okay.
Independent
committees can't coordinate.
They cannot.
Was these two entities coordinating with the Abrams campaign?
That is the subject of an open ethics complaint.
Okay.
So I can't really comment publicly under 3.6 of the bar rules. I can say that is something that has been and is being investigated. I think I can say that at previous hearings, we presented evidence. And some of that evidence certainly gave credence to that question of whether or not coordination occurred.
Okay. Well, Stacey Abrams created the New Georgia Project,
She did.
and did she run it?
So, and again, I'm gonna try and answer your question, but I'm gonna limit it to what has been discussed in public hearings, because that's really, I think, where I'm confined to.
Yeah.
She created it in 2013. The claim was she left the organization in 2017, right before she kicked off for governor.
Okay.
But Secretary of State business documents showed that through the 2018 election, the New Georgia Project was still headquartered at the office suite that was her corporate office, Third Sector Development. Checks were cut to New Georgia Project and sent to the USPS box or the UPS box that Third Sector Development had, leased out originally.
That's a new term, Third Sector Development. Is that an entity?
It is, my understanding is it's a corporate entity that she founded in 1999. And was essentially her corporation throughout that period of time.
Any other ownership of that Third Sector Development Corporation other than Stacey Abrams?
Not to my knowledge.
So she has corporation, she's taking money from that corporation and cutting checks back and forth to New Georgia Project.
And I don't remember if Third Sector Development I think they may have given a little money to New Georgia Project. New Georgia Project was incorporated. I should have said this. They were incorporated in 2017 when she left the organization to run for governor, but they were founded in 2013. And when New Georgia Project was founded, they were founded as a division of Third Sector Development.
Okay. And so that's where all your antennas and radars went off, because you've got the candidate themselves and they are whatever you're going to call independent committee that have common ownership, founding, et cetera, and they're working in tandem to elect Stacey Abrams.
I think the fair way to put it is the concern was this is a shadow super PAC that's not registering and disclosing, that's advocating for the person that founded them and is still headquartered at her corporate address.
Good enough. Are there other individuals that work for New Georgia Project that have a separate executive director, or is that Stacey Abrams?
No, I believe Insei Ufot was the executive director of New Georgia Project during this
Slow
relevant.
that down. Our court reporter ain't gonna be able
Yeah.
to spell that, neither can I. What's that name again?
Insei, NSE, last name Ufot, UFOT.
Okay.
She was the executive director of the New Georgia Project during this 2018, 2019 time period.
All right. Do you have any idea how many employees that organization had?
Once upon a time I did, those bank records, the little hazy.
How much money did that organization raise?
So they illegally raised, because they didn't disclose any of it, roughly $4.2 million during the 2018 general election,
And
primary and general election, excuse me.
you found that out by subpoenaing the bank records or something like that?
Correct.
And could there be other money that just was never disclosed or you didn't track down?
Possibly. All I know is what we got through bank subpoenas.
And do you have any proof of where that money came from?
We do. We have the full roll of who all the individual and corporate donors were.
Is that accessible to us?
It is.
Did we subpoena that document from you?
It is.
Have you produced that?
Oh, have you subpoenaed it? No, you have not.
We asked for a lot of your documentation on investigation, but we didn't know how specific
Yeah.
to ask for. So you may be receiving another subpoena.
Okay. And it's available as a closed case under the Open Records Act as well. In fact, I see some press friends who have requested it in the past. So
All right.
we can provide that. I think we had at one point PowerPoint presentations that, had the graphs of all the names of the
Okay.
donors.
If you can, at this point, find those again.
Yeah.
Provide them to us, or our attorney, Josh Belenfante, we
Yeah.
would be interested.
Okay.
So basically, you track down where the money came, 4.2 million anyway, was donated to this organization. You were able to figure out where it came from.
Took a while.
Okay.
Took a while, but ultimately, yeah,
And were you able to figure out how the money was spent?
we were.
How was it spent?
It was spent on staff. It was spent on canvassers, phone bankers. They had, I think, 9 or 10 district campaign offices throughout the state. A pretty complex political operation, I would say, pretty robust. And I do want to point this out. 4.2 million is the number we're talking about with this entity.
Okay.
That may, to some people in the political sphere, not seem like a lot now. But in 2018, that was a ton of money. In 2022, Governor Kemp and Miss Abrams ran against each other again. And in 2022, the governor raised total a little over $100 million. She raised almost 140.
What about in 2018?
In 2018, 22 million and 27 million. So this is a pocket of illegal money that's 15 to 20% of the whole kit and caboodle of the campaign.
Okay.
That's a significant influx, as I don't need to explain to y'all.
Right.
That's a significant amount of money at the time.
In our Senate Resolution 292 that gave us the authority to explore these issues, it was in the whereas clauses or whatever that the 4.2 million in donations was received, and 3.2 million of dark money in support of Stacey Abrams' campaign for governor was spent. I'm still fuzzy on the dark money. It sounds like the light got shined on it when we figured out it was 4.2 million.
Right.
Is that the money spent was from that pool
Yeah.
of money?
They didn't necessarily spend all of the 4.2 raised.
And that's considered dark money because it was never disclosed.
Correct.
Now you guys investigated and figured out where that money came from
Correct.
and how much of it got spent to support Stacey Abrams.
Correct.
So most of it,
Most of it.
3.2 out of the 4.2 was, well, where'd the other million go?
So a lot of that bled over into 2019. A part of our case also involved so they were an illegal independent committee in 18. They became an illegal ballot committee in 2019. And they spent like $500,000 maybe on the Gwinnett MARTA referendum.
Okay. So a whole nother campaign violation. They acted as a super PAC without disclosing, and then they acted as a ballot initiative committee.
Correct. And they raised money in 19 too, and they didn't spend it all. And some of that money was left over in their operational account moving forward, which didn't really involve us at that point. But yeah, those are the figures that were raised and spent.
So when confronted with these allegations, what did Stacey Abrams or this lady, I can't pronounce the name that you just spelled for us, what did they say?
Initially, so we filed our original complaint, our charges in September of 19. So
It took you a year or so to investigate.
6 months.
Figure it out.
Yeah, 6 months. And we filed our initial complaint and we subpoenaed bank records. They responded by seeking to quash our bank records and arguing we did not have jurisdiction over them. That motion to quash was heard by our commission in December of 19. So within 3 months, the next commission meeting. And the commission members denied their motion to quash in December of 19 and ordered them to comply with the lawfully issued subpoena that I had signed.
What type of judicial review is there for commission rulings? Can that be appealed to
It
a
can.
court?
It can.
What courts it go to?
It would very likely go to the Superior Court of Fulton County.
Okay.
And ultimately that's where we went. Normally, if someone wanted to appeal a decision of the commission, they would file an appeal in Superior Court. The interesting thing about this case is after they were ordered to comply with the subpoena, they just didn't.
Just didn't fail to comply.
So
that made you have to go to court for judicial enforcement.
So we had a motion to enforce in Fulton County.
We played this game too with previous subpoenas in this committee that were rejected.
And at the time, you're going through the COVID pandemic. So It took a while.
I was gonna get to that. We're
Yeah.
talking about an 18 violation.
Yeah,
A 19 investigation and a consent order issued in January of 2025.
yeah,
So I guess you're walking through why it took so long.
I am. And,
Okay.
and I'm gonna,
So you were forced to go to court
yeah,
to enforce the commission's ruling that these documents had to be produced.
correct.
All right.
And so we go in early 2020. It takes about 2 years. Fulton County ruling. We had to appeal it to get it reversed at the Court of Appeals, and the Court of Appeals reversed it. Goes back to
So the
Fulton.
Superior Court would not enforce your subpoena.
The Superior Court relied improperly, misunderstood a different ruling that made them think they didn't have jurisdiction, and they did.
All right. And so you appealed that to the Court
Court
of
of
Appeals.
Appeals.
What they do?
They agreed with us. They say, you clearly have jurisdiction to enforce. If it's not you, then there would be no one to enforce.
Okay.
So we go back to Fulton County. We get a judgment in our favor. Mostly in our favor. It was sort of a split decision. We go up to the Court of Appeals for clarity. They rule again in our favor. And they send it down a third time, at which point the Superior Court enforces more or less our subpoena as we had requested.
Okay. And that was not appealed by the New Georgia Project?
No.
Okay. And so then you finally got the documents.
We got the documents in.
Was this just Four Corners defense kind of rope-a-dope trying to delay you from uncovering the
It was delay.
deeds?
It was delay, obfuscate, point in the other direction, blame anybody. It was everything to avoid accountability, in my opinion.
And so this drug this out beyond the 2022 election.
Yes.
It did not become public and could have
Well,
negatively reflected on Stacey Abrams if it had.
no. So we get the bank documents in early 22 and we amend our complaint with specificity now, because we can say it was 4.2 million. Here are the donors. We can say it's 3.2 because we've been in the bank records. We actually have because I'm cognizant of this. Okay. Anytime a government watchdog, whatever you want to call it, takes too much time, the public loses trust in the process. So it was important to me and our staff that once we got the evidence we had been seeking for 3 years at that point, we not just sit on it. So we had a probable cause hearing in the fall of 22, at which we present all this evidence. And the commission, which I pointed out earlier is a bipartisan appointed commission, unanimously ruled they had broken the law.
So this before or after Election Day in November of 22?
It was before, I think it was in September, maybe.
Okay.
They found probable cause and said it needs to move forward.
Okay.
At that point, the New Georgia Project filed a federal lawsuit. And the gist of the federal lawsuit was essentially to have Georgia's super PAC laws thrown out as unconstitutional. It would have resulted in super PACs being allowed to operate in the shadows with no transparency, spending, raising, whatever they want. And it was done, in my opinion, to avoid accountability, because if these laws are overturned, we don't have jurisdiction.
Right. It would have unraveled what you had already obtained, a ruling against the New Georgia Project.
That's correct.
Okay.
So they filed a federal suit in the fall.
Taxpayers funding all this for us?
They are.
Is Attorney General the one that's prosecuting it on your behalf?
He is.
Okay, because he's the state's attorney.
Correct.
Okay.
Late fall, early winter, however you want to characterize it, of 22, the federal suit's filed. And it was filed quick. I mean, we usually get that referral letter to the AG within a month of our hearing, 2-3 weeks. They beat us in federal court to the punch.
Trying
By
to stay your activity.
trying to stay our activity.
Right.
And so we go to district court. We argue that based on the younger precedent, basic federalism, this is a state issue. And there is an existing state litigation over a state law. This needs to be litigated in state court before the federal courts get involved.
And I guess the federal issue is freedom of speech.
Correct.
The United States Constitution guarantees.
Correct.
Okay.
The district court disagreed with us, although the district court didn't agree with the New Georgia Project. and I should have brushed up on this and I apologize for that, but I remember that decision ruling in New Georgia's favor, but not for any of the reasons they argued. And we felt pretty confident it was an incorrect decision. We appealed it to the 11th Circuit, and the 11th Circuit unanimously ruled in our favor and ordered the district court to dismiss the federal lawsuit so that we could proceed.
So how long did all that delay take?
That took until mid to fall 2024.
All right, so they accomplished the goal. It kept you from impacting the 2022 election by reflecting negatively on Stacey Abrams' campaign. Because they could honestly say, this is tied up in court. We have not admitted to these allegations. It's politics or whatever.
Yep.
Okay,
So we're
we're getting closer. You got us to 24.
close. So late 24, fall of 24, late summer, we finally get the federal case dismissed. We can move forward in the administrative law hearing for a full bench trial. And at that point, they want to engage in negotiations to avoid the trial. Because I think at that point, the evidence was overwhelming. The argument was always going to be federal law shouldn't allow you to have jurisdiction.
Yeah. So you had smoking guns. You
Yeah.
had the contributions. You saw where they went and you saw it was spent and was never registered or disclosed to our state ethics commission.
Correct.
So that allows a complete circumvention of this transparency that we're all trying to obtain.
Correct.
So
So-
now the gig is up.
They want to negotiate. And look, it's tax dollars. If it means a resolution versus another year and a half of trial and appeals, I'm not going to say no to them admitting they broke the law. Now, the terms of negotiation were simple. You're going to agree to everything you did, and you're going to pay a significant fine. And ultimately, they agreed to do that.
So what exactly did they agree to? What violations did the New Georgia Project, the New Georgia Project Fund, or whatever action fund, what did they admit they had done that violated our campaign finance laws?
They admitted they failed to register as an independent committee or a super PAC. They admitted they failed to file all required disclosure reports in the 2018 primary and general election. They admitted they failed to disclose over $4 million in it was 4.216, so $4.2 million that they didn't disclose in the contributions they illegally took. They admitted failing to disclose in those reports just over $3.2 million in political expenditures. They went on to admit that they failed to register as a ballot committee in 2019 on the Gwinnett Martyr referendum, that they failed to file certain reports as a referendum committee, and that they failed to disclose $646,000 in illegal contributions in 2019 and about $173,000 in illegal expenditures in 2019.
What made those contributions illegal? The fact they were not reported?
Not reported, not disclosed. No one knew they were making them until 2022 when we get the bank
Is
records.
that money over and above the 4.2 million you had uncovered?
Correct. So they admit all that.
They admitted their activity was in direct support of Stacey Abrams or other Democratic candidates.
Yeah, I mean, they admitted all the allegations that we just covered that we made about the money and the evidence we provided of the mailers, things like that.
You fined them $300,000.
Correct.
Was that in a negotiated amount or was that something imposed by a judge or a commission?
It was a negotiated amount. And I want to be clear about this. Personally, I think it should have been higher. But the reality is, as we see now, they didn't have it.
They must have that money left sitting in their bank account.
Yeah.
You just drain the rest of their resources.
I haven't seen the bank records in a long time, but that would be a fair assumption. To me, the question was simple. It had to be a fine that was significant in size because the violation was significant in size. It had to reflect what laws were broken. But
Otherwise, people just keep violating it.
yeah,
Catch me if you can.
if it's a nickel crime, who cares is the attitude. It had to be a significant fine, but it had to be a fine they could pay, because if I fine them $1 million knowing they can't pay it, then there's really no penalty. Like that, to me, that is a hollow you know, it's just not it's not a real penalty to say you agree to this and we all know you're not gonna, or if we demand a number they can't pay and they say, well, then we'll just drag it out in litigation. That was a number that was significant in size, but also brought the case to a close after 5.5 years, which was important.
Well, it occurs to me it's hollow anyway if it's against an entity like a corporation. No individual's been held responsible. You know, the candidate had the benefit of $4.2 million spent on her behalf that was illegal. And this entity, which is now probably defunct,
Yeah.
gets fined by just getting caught at the end after rope-a-dope, four corners defense, finally cough up to 300,000. I don't see where anybody was accountable. No, like you said, individual campaign finance,
Sure.
the candidate's got to pay the money back.
Right.
Here, there's nobody to pay it back because it's a corporation.
I'll say I'm operating with the tools I have.
Well, we're trying to figure out
Yeah.
what other tools you need.
Yeah.
Because if I want to do this right now, I could do it and say, get me if you can. I'm gonna drag this sucker out for 5 years, and the campaign's gonna be long over. I mean, I might have been elected and out of office, and all you're gonna do is make us pay whatever money's left over in my bank account, my controlled entity's bank account.
Right.
Would you like to have personal accountability for whoever's doing these violations? I mean, it's a human being that's making the decisions. And I'm not saying for sure it's Stacey Abrams or somebody else,
Sure.
but whoever set this scheme up and put it in operation and pulled it off is still out there. And I don't see why any of these other committees out there that are registered with you or not registered are deterred from doing it.
I think
Tell me the tools you need so we can keep this from happening in the 2026 election cycle.
yeah, I mean, you kind of touched on it earlier, I think, and I'm quoting some of what my commissioner said at the hearing, that they thought it should potentially be criminal, or it should have implications on the ability to serve in office if you can prove that coordination element. Those are policy decisions, respectfully, not for me, but I think it's a very fair point to say there are gaps in accountability within the current system.
And the current system that it ended in this consent order last January did not call for any kind of criminal penalties for knowing, willful, intentional violation of our campaign finance disclosure laws.
No.
And that was done in a way to avoid any accountability of where this money was coming from. And I have no idea. You got the list. We're going to get it from you.
Sure.
I mean, it might have been George Soros. It might have been 1,000 individual donors around America that kicked in $100 each. I don't know.
Right.
But the press corps that's here was not allowed the information they needed to say this election is being influenced by A, B, C, or D donors.
Right.
And this New Georgia Project is not revealing to us their activities and how much they're spending to influence an election when we require them to do that by law.
Correct.
I want to close that loophole. I don't want the next General Assembly to be sitting here in 2031
Sure.
talking about the 2026 election that somebody stole by illegal contributions or non-reported contributions. I mean, for all we know, it could be China doing it or something.
Right.
Yeah? That's just as illegal to
Sure.
take foreign money.
Sure. I think I think
Go ahead.
I think one area where, just candidly, these are hard to prove is the coordination angle. And if you're looking at something that can strengthen our ability to prove things, and then whatever sort of accountability you legislate on the back end, right?
Right.
But proving coordination is a huge thing, because then you bring a campaign directly into breaking the law. You can prove it.
Well, this one was kind of like what we would call in sports world a layup or a slam dunk. You've got the named candidate that's being supported that created the entity that's supporting them in violation of the law. Unless they can say they've somehow totally disassociated themselves
they've
from
said
their
that.
own.
They've said that.
Okay.
Did
you buy that, or did they concede that they had coordinated?
They have not conceded they coordinated.
Okay.
It would be useful in the coordination element, because all right, take a campaign committee and potentially violating the Campaign Act. They didn't disclose yard signs or mailers. That's sort of content based, right? We know they did this, they didn't tell us it. Coordination is communication based. The issue isn't did they spend the money? The issue is were they talking to the candidate about doing it, and was the candidate directing them to spend the unlimited dollars in the way they wanted to circumvent contribution limits? We don't have a great mechanism to question people about that right now. We have arguably deposition power at the administrative law hearing, but you got to prove the case before you get there. If there was the ability limited to independent committee investigations to potentially question individuals under oath before we have to prove to an evidentiary burden, I think that would significantly strengthen your ability to prove coordination with these, super PAC.
Slow down and say that sentence one more time.
Yeah,
Because we're learning all these concepts, and the general public that's
sure.
watching this, say it again.
So
It was very good. I want to hear it one more time because I don't know that I comprehended the entire scheme there.
to prove a campaign broke a law, let's say a campaign didn't disclose how they spent all their money. There were yard signs. They didn't ever tell us there were yard signs bought. There were digital billboards. They never told us that. That's content. That's conduct. We can see it happened. We can see the billboard, and we can see that it's not on paper in the report. Coordination is an entirely different animal. Coordination, and the problem with coordination is if a campaign coordinates with a super PAC, they can telling the super PAC how to spend these unlimited dollars.
Yeah, designing the mail pieces for them or the TV ad or whatever.
Talk about these issues.
Yeah.
That's what we're.
Here's my campaign platform, promote it.
If a campaign coordinates with a super PAC, they can circumvent the contribution limits that everyone else has to play by.
Because if you were going to donate to the campaign, it's $3,300 or whatever is statewide.
Statewide, yeah.
A PAC, you can give them as much as you want. So
Right.
you circumvent that limit.
Yes.
If they're coordinating,
If-
doing the same things with that money that your campaign wants them to do with it. or
Correct.
Would have spent it for themselves.
Correct.
And that's the coordination. How do you prove
That
that this campaign wants the money spent the way this PAC is doing it?
and that's the challenge, is because proving coordination is not conduct based, it's communication based.
How do we help you prove coordination? Legally, statutorily, is there a way? Is there some definition of coordination? Is there some evidentiary standard or proof?
I think if you can provide the ability to depose individuals in the course of an existing investigation, like there's a complaint's been filed, and I want to be very careful. I'm not talking about an ethics commission run amok that can do whatever they want. But if there is an ethics complaint filed and we're trying to figure out, well, were they coordinating? Or maybe there's a third party complaint, maybe there's some investigation happening. The ability to question people under oath before we go to a probable cause hearing. Because by then the cat's out of the bag. If you're at a probable cause hearing, you've got to prove the case. Our friends with the cameras are there every time. It's not really a legal deposition type setting. It's a litigation setting. If there was an ability to question certain people, let's take this case. If I had the ability to question a number of people at the New Georgia Project in 2019, 2020, maybe we could prove coordination. But without that, you're never going to prove coordination unless you have whistleblowers or someone has made a statement in writing, a document that can prove it. And that's not all that common.
Unless you have those teeth, we're never going to stop dark money from influencing our elections.
I think it's a strong element to curbing it. Yeah.
Are you satisfied with the conclusion of that investigation and the consent order?
I am. And I recognize, that it's not a perfect resolution, but I think it's the best resolution that could have happened within sort of the framework of what we were working with. I wish it had happened sooner. I wish they hadn't, tried to hide at every turn, tried to strike down Georgia law. I hate that it took the public 5.5 years to find out what we knew happened. But given those realities, I think it is a good result. And it is the largest fine in the history of the Ethics Commission because it was the largest instance of a group illegally influencing an election that we had ever uncovered. So I think the message at least publicly resonated. I think with the tools we have, it was the best result you could get.
Are there other pending investigations of similar complaints?
Yeah,
Not necessarily the same group, but just
Sure.
this type of circumvention of the law?
sure. So, and I can say this because it's been reported publicly by the press, so I'm not violating 3.6 or anything like that. We're actively prosecuting the Georgia Republican Assembly, the GRA, for doing the same thing. Smaller scale in terms of the amount of money, but it's the same concept. Illegally spending money without disclosing to influence election results over the last several years.
All right, who's this group?
It's
Georgia Republican Assembly?
yes, Georgia Republican Assembly, GRA.
What are they alleged to have done? You haven't found a
Right.
conclusion yet, no determination?
No, the
Is this
hearing.
public when somebody files a complaint?
Yeah. So,
Okay, so you're not revealing
No.
any secret information?
and that's why I'm being sort of not cagey, but
Yeah.
careful about what I say and what I don't say to make sure I'm only saying something's publicly available.
Okay.
So they're alleged over the last several years to have spent money influencing both legislative Republican primaries and local, I think, Board of Education primaries in different areas in the state. They're a political group, kind of a wing apart from the typical state party structure. And we have accused them of, I mean, do you know, I don't remember the amount of, it's, a couple $100,000 in targeted sort of legislative and local races.
Donating to campaigns or sending out mail pieces or,
Mail pieces, that type of activity.
okay. And had they ever registered as a political action committee or a campaign committee or a
They
independent committee or any of those?
they had registered as a political action committee, but they had never registered as an independent committee disclosing all of the actual independent committee stuff they were doing.
Were they coordinating with campaigns?
I don't know the answer to that yet.
So you'll go after Republican groups or Democratic groups. It doesn't matter to you.
Correct.
Okay. Are you ever accused of being partisan in your activities? This ought to help defuse that somewhat if you're revealing that you're going after a Republican group now.
We've gone after Democratic groups. We've gone after Republican groups. GRA is not the only Republican group. The Freedom Fund, a few months ago, which is sort of aligned with the Freedom Caucus. We hit them for, it was a small amount, but their violations were small, but same concept. That was the narrative early on when we announced this about the New Georgia Project, it was a partisan hit piece. I've always taken the position that I got to look myself in the mirror the next day, and I'm not willing to compromise that for politics. We'll go after Republicans. We'll go after Democrats. These people broke the law. It was clear to us. We did our job. And they admitted it, right? Like, it's not even me saying it at this point. They admitted it. I hope after 7 years, the belief that anything about this commission is partisan has been diffused. We work with, I speak to the Democratic members and caucuses. I think we're actually working right now. I think the leader probably knows that we're working right now with Nikki Merritt and lining up an educational on the new system to help them make sure they understand it before it goes into effect so they don't have any problems.
You're talking about the new reporting system.
Correct.
That's an electronic thing we're trying to make it streamlined or more user friendly, let's say.
Yeah. So look, it's a little rambly. I apologize.
No, you're educating us. That's what we need.
I'll go after Republicans. I'll go after Democrats. That's what the job is. That's what people should expect. And, people are going to point the finger to avoid accountability. That's human nature. But, you know, I'm happy with our record over 7 years.
I am going to allow the minority leader to ask any questions he may have at this time. Senator Jones, are you still
I'm
clued?
still here.
Do you
I
have
am
any?
still here.
I'll turn it
I-
over to you, Senator, if you have any questions you'd like to ask.
No, I just want to thank Dave for coming. I did not have any questions, Chair. I did not have any questions. I appreciate the information.
Okay.
Mhm.
I need you to help me with some of the documents so we can review and see how this played out, what evidence you obtained. And I need a little bit more specific guidance on how you think we can tighten these laws up to essentially protect the public.
Sure.
And what we're wanting to do is to keep transparency so that folks can be held accountable if they're trying to influence elections or advocate for positions. We don't want to stop them from doing it,
Right.
but we're wanting it to be transparent to the public so we can know who is pushing these different agendas, so to speak. And we also want to make the system fair so that big money doesn't dominate our politics. I mean, we have these campaign contribution limits so that normal people can have an equal influence on the funding of campaigns, which is an expensive proposition. And that those people don't have to worry about this anonymous money or unlimited contributions coordinating with these campaigns to circumvent that intent.
Yeah.
Am I narrowing this down pretty
You-
close to what we're
You
trying to
are,
do?
and I think this kind of gets into some Supreme Court cases that have come out recently. You know, the Eternal Vigilance case this year, City of Guyton, a few of those.
That's not, Josh Belenfante may know as our
Yeah.
counsel. We got some lawyers up here, but I don't think we're clued in on that. Give me a little overview. Go ahead.
So there have been a few cases over the last 5-6 years from the Georgia Supreme Court, which have sort of indicated maybe a shift away from pure deference to administrative agency rules and opinions. And so some of these areas we're talking about, like coordination, for example, is not defined in Georgia code. Coordination is referenced in administrative rule and opinion. But if someone were to challenge that and the courts were ultimately to say, well, we're not giving deference to the administrative opinion, coordination is not something we have a legal definition of. What is express political advocacy? That's not defined in Georgia code. And at the risk of going down a sort of wonky Supreme Court hole here, we don't even currently recognize necessarily what the U.S. Supreme Court has said. But it's all based on administrative rule and advisory opinion. We don't have what express advocacy is defined anywhere in Georgia statute. I think it would make some sense to look at doing that in the event that these agency opinions maybe one day aren't deferred to, so that we don't find ourselves in a position where there's nothing controlling.
So essentially, the courts are now saying that they will not defer to an agency rule or regulation unless it's clearly delineated in the statutory authority.
I think that's right. And we've tried to be careful over the last 7 years not to institute any administrative rule that's just whole cloth invented. Like any rule we've passed has been rooted in statute. But these are issues of degrees.
So it would make your job easier if we defined some of these terms or matters that you have addressed in your rules and regulations statutorily, so there's no question whether or not you exceeded your delegated authority.
I think that would be
Okay.
correct.
If you have some specific suggestions on that, and maybe it's to take some of your rules and regulations and to codify them.
Right.
Can you let us know that?
I can.
Because we have an upcoming session and we're gonna try to, the best phrase I know is to restore public faith in this entire public sphere of campaign finance law.
Yeah.
Okay. That would be helpful to us. And the other thing that you're saying that I'm clued in on is some type of personal accountability for these knowing intentional violations.
Yeah.
Because I'm not so sure our system right now deters that. If the worst thing that can happen to you is the illegally obtained contributions you've got that hadn't yet been spent get forfeited to the state, that's not so bad. It's different if you're thinking, I got to write you a check and pay a personal civil
Right.
penalty, if you want to call it that, or
Right.
criminal fine, or I might be going to jail if I'm doing this intentionally and just, then delay until the election's over and nobody can hold me. I hadn't admitted wrongdoing until the election's done. And, if I won the election, I'm already the governor. If I've lost the election, then who cares?
I assure you,
tried my best to win by using illegal money,
I assure you, your frustration I have lived. So
Okay.
I'm not disagreeing with you.
All right. Senator Dolezal, I see you or saw you on the screen. Did you have an issue you wanted to raise? Our rules don't permit you to directly question the witness, but you got anything you wanted to comment you needed to make?
No, I'm good, Mr. Chairman. Good to see everybody.
All right. Well, good to see you. I just saw your face popped up on the screen. I'm glad you were able to participate. Is it legal if we were to pass a statute to cap the donations to these super PACs? I mean, that's how this particular circumstance circumvented our laws.
I think you have the ability to do that.
That doesn't go afoul of free political speech, Supreme Court decisions. Everybody's cutting their eyes over at Josh Belenfante, our committee counsel. Because we don't want to do something that later is shown that, you're not allowed to. Yeah, I don't even remember all the details of Citizens United case.
Yeah.
That's the one that comes to my mind because it dealt with public.
I'd
campaigns.
want to take a closer look at that before I answer one way or the other.
Okay. And it may or may not be a good idea. Maybe we ought to address that only to these independent committees,
Right.
or, because some of them are that are advocating for broader issues. We don't want to deter that.
Right.
I mean, if we have a ballot initiative on legalization of gambling in Georgia or marijuana, pick a controversial subject. I think everybody wants to be heard on that.
Yeah.
And I think they would probably have a valid beef if they were say, well, we're not going to let you spend money to be heard.
Right.
Because unfortunately, in today's world, that's what you got to do. You got to spend money to either get on a TV advertisement or send a direct mail piece or be on the radio or to communicate your message in some way. Right. Back to New Georgia Project. In your investigation, were you able to determine any individual that you felt like was in charge or was coordinating this or sort of, leading the charge, coordinating, or just kind of running the show?
I think the individual I mentioned, Indesay Ufot, was in charge of the organization at the time. There were a couple other people that I think were pretty high up, but I would say she was the point person.
So when you were negotiating this consent order, who sat down on behalf of New Georgia Project to?
So she was, I believe she was gone by then. We dealt with the lawyers from the Elias firm is who they hired to represent them. So we dealt with, they had local counsel, but I think it was primarily the lawyers out of DC that we negotiated with.
Right. So they were negotiating on behalf of Ufot or her successor.
Correct.
Senator Gooch, you have anything to add?
Oh, I have a lot of questions, but we're not asking questions.
Okay.
It's troubling.
You may wonder our system, and a lot of our committee meetings in the legislature, all committee members can ask questions. In an attempt to keep this from being a free-for-all circus, everybody grandstanding for their own political purposes, we have agreed in our committee rules that only the chairman and the one designated member from the minority party are permitted to ask your questions. Now, there might be a whole bunch of us that have more questions that I didn't ask, and we may call you back, or we may get Mr. Butler. Okay. In the course of your investigation, did you subpoena communications like letters and emails and things between these individuals with the New Georgia Project, or just the bank records?
We subpoenaed communication between the New Georgia Project and Abrams for Governor. There were communications. They were not. There were not many. They were not terribly substantive.
Okay. So if people are savvy enough to be circumventing the system, they're also savvy enough not to put it in writing that, hey, will y'all go ahead and send the mail piece for us now? Or here's the ad we prepared for you to pay for and do.
Yeah.
All right. So you wouldn't really expect that was going to turn up much
No.
if it was a knowing willful violation.
Correct. I mean, and I think we have to be fair. Less sophisticated, less significant operations might violate this, not having any, but if it's knowing and intentional, generally you're going to be smart enough not to leave that trail.
Do you ever learn of organizations that are influencing elections that haven't registered, and you reach out to them and say, hey, do you realize the law requires you to register with us and make these reports? I can imagine on the local levels, I could see that happening, but just advocacy groups that didn't realize they're required to register if they're going to start advocating for a particular ballot initiative or candidate.
Yeah, that happens. And I'm not saying you excuse it, because we don't excuse it, but we certainly understand that it's not malicious. It's, we didn't know, and with those groups, it's usually, oh God, we're so sorry. What do we do to make this right? You do just see more of those just unintentional lack of knowledge type violations at a local level.
Okay. And you just educate them, and they comply then and begin to report.
Yeah, and listen, there's still a consent order, because if the law was broken, we have to recognize that. But we're not gonna try and make an example out of someone who, I'll give you an example. We had a woman running for local office who called us to inform us she had filed an ethics complaint against herself because she had gone to her local clerk and they said, this is what you do, this is what you don't do. If you don't do this, you don't do that. So she thought she was good. And then she realized, oh my God, I've broken ethics laws. And she was adamant. She was like, well, I have to pay some sort of fine. And we're like, we're not going to try. Listen, this is not the case to bankrupt you or, but you do see a lot of that at the local level.
Okay. So I'm just thinking of more questions in my head of how we can keep this from happening again in the future. That's sort of our charge. And it sounds to me like we might consider creating criminal offenses for some knowing, willful, intentional violations would apply to a person.
Sure.
We could also codify your rules and regulations to make it very clear that you have the delegated authority to enter those rules and regulations, so they can't be challenged as
Sure.
beyond the authority we delegated to you.
Right.
Anything else you're thinking of that would be helpful to you?
If there's an appropriations chairman that wants to increase the staff resources, that's always a decent idea in terms of enforcement.
Okay. Tell us again your background. So you're a practicing attorney or were a prosecutor.
Yeah.
What was your role? What did you do before you got drafted into this?
Yeah,
executive
before I
director role?
got sent to purgatory. I spent 7 years in the Douglas County District Attorney's Office. So I began my career actually working across the hall down a floor for Speaker Ralston when I was in law school. And I worked for the speaker, and then I got hired coming out of law school by the DA's office Worked it there everywhere from intern up to the chief assistant role, everything in between. Pretty much the only type of criminal case I didn't try was death penalty case. Spent 7 years there before getting, as you said, drafted here. But I've been a lawyer for getting close to 15 years now.
Is the New Georgia Project still in existence, or New Georgia Action Funds?
No, my understanding is a month or two ago, maybe a month ago, they went defunct. That I don't know if bankrupt is the right term, but they dissolved, and they are no longer in operation.
We have another charge to look into, $2 billion grant that was given to a different Stacey Abrams organization from the federal government. Do you feel any need for us to be able to more closely coordinate with the federal government, or to require them to, if we're allowed to educate us about money that's spent to influence elections?
I think you have a federalism issue there.
So that's beyond your authority
Yeah.
right now.
Yeah.
You heard about that allegation.
I have. I don't know really anything about it other than what I've read in the papers. You know, I really don't have a good answer for you on that.
Okay.
Just not informed enough to know.
If a Georgia organization received federal funds and used them to influence an election, would that violate our campaign finance laws, or do we need a new provision to make it clear?
Yeah, I don't know that there's anything that's federal, right?
Yeah.
Yeah. So there is currently in law a prohibition of government dollars influencing an election or going to a candidate or entity, ballot committee, campaign committee, independent committee.
Say that again.
There's a prohibition against government dollars being given or utilized to influence elections,
State or federal dollars?
state and
Okay.
local. I don't think it's federal,
All right.
because I don't think well, I'm not saying we can't prohibit that, but I don't think we have.
Okay. Back to personal accountability. If one of the individuals that you question in the course of your investigation is untruthful to you, is there any remedy? Is that a false statement, or does it have to be under oath before?
I think it has to be under oath. So
You can't put people under oath until you get to the hearing. Should you be able to?
that's kind of the deposition area I was talking about, questioning in terms of whether there's coordination in a case or not. You know, they lie to us. There's nothing we can do about it. And if they tell us they refuse to talk to us, there's nothing we can do about it. I think that would change that calculus.
Okay. Well, I appreciate your time with us this morning. And if you would, please coordinate, Mr. Belinfante, our counsel is going to ask you for some of the documents that I've mentioned today that are public records. If you would be willing to produce those without a formal
Sure.
public, request for information or what under the open records law,
Right.
we'll do that. And if you feel like you need a subpoena, we will give you a formal subpoena to ask for some of those documents. And if there are any other ongoing investigations that we should know about, let us know. Because we have pretty broad jurisdiction here to look into it, because we're trying to figure out how to make sure this 2026 election is as fair as possible.
Sure.
And not subject to undue influence where either exceeding or circumventing contribution limits or violating these coordination rules. I'm thinking we may need to clarify what is or is not coordination, or what might be evidence of such, those type of things, to make your job easier, because it doesn't sound like you can put people under oath in your investigation.
Correct.
So if you were to go to somebody with New Georgia Project and say, why did you canvas with the question, do you support Stacey Abrams or not? Or why did you put TV commercials on supporting Democratic candidates and they lied to you? You can't do anything to them.
Yeah, if the violation was, let's take a hypothetical. If we think there's a case where someone is coordinating and therefore exceeding contribution limits with, a campaign and a super PAC, if that's all we have, we can't really put them under oath till we get to the ALJ. But that's kind of the tail wagging the dog, because you don't get to the ALJ without probable cause of what happened.
Yeah.
And so that, in my mind, at least, that's where I'm thinking it could be very useful.
Okay, maybe some type of false swearing or false statements or false documents type thing. If you're misled intentionally, there should be some repercussions to help you do your
I
job.
think there's a lot of ways to you could go about it. Yeah.
Okay. All right. Well, thank you for being here and thank you for your service in that difficult job that you have.
Thank you.
With that, we are going to adjourn for the day. As members try to put the note down that we anticipate we'll be back December 17th or December 18th, this room, 10 a.m. All right, we're adjourned.